Welcome to part 5 on my series on power. Today is a discussion on the topic of the law as power and how the interaction of a judicial system and a legal system works as a proxy or a facsimile to power. And philosophers like Hobbes or jurisprudence scholars like Schmitt have discussed this at length, and we can delve a little bit into how they think, but also what we can glean from reality. Now, when we deal with legal structures, it's important we aren't being normative and that we use the is and not the ought, which is a super important concrete principle of Schmittian establishment of sovereignty, but also the function of a legal system. To start with is a quote here from Hobbes that I think sets the tone perfectly. The law of nature accepted, it belongs to the essence of all other laws to be made known to every man that shall oblige to obey them, either by word or writing, or some other act known to proceed from the sovereign authority. So I think in that sense it's important to remember that the law is bound to an authority, and the authority is usually the sovereign, and the sovereign, as Schmitt has said, is made known during an extreme in the exception. So it is to say that the authority and the law are so intertwined it becomes a power of its own. It is this corpus, this soma of power, represented as a set of facsimile but a proxy for the wills and wants of the sovereign himself. And it's known, as in it's publicly disseminated, to a degree that it's enforceable and if you violate a punishable, and sentencing is reflected in that. If you know a crime or something is immoral, it's usually reflected in the legal structure of your state or your principality. And it would be to say that if you are in a like your English common law system or in a constitutional system, there's still a fairly strong notion of what's legal and illegal. And this is just the reflection of the authority of the sovereign and how his views are both instituted but also respected. As part of Weber's topology on power, we can obviously understand this one as a rational legal power, and that it's very strict in regards to how we define it. So the definitions, but the vernacular and the syntax and everything that you use in law has to be very specific for reasons that become obvious the more you deal in legal disputes, but contracts and other types of tort or common law. The way I would say to start, and if you're just being introduced to the legal system, is to go through Hobbes's Leviathan. It is quite a large text, about 600 pages, but it's very valuable in how his considerations are around particularly a monarchy and a construction of a state, and how the sovereign is then and what they're responsible for. It's a good counter to John Locke, who had a similar type of series on books that he wrote that relate to states and the power of states and the structure. And it's also good to read Rousseau, who also did The Rights of Man, and how he talked about similar constructions around the legal system as it equates to a government. And these are foundational texts, you would say, in the realm of legal political philosophy, or at least jurisprudence to a degree. The way we can think then, I guess, around the triumvirate of how authority, law, and threat interacts, and we can think of threat here maybe as might or force, is that you have an authority as established in a hierarchy, and their wills and wants are laid down in this very strict fashion as laws. Now, they can be tacit to a degree, but normally, and this in the sense of not normative but actual, you have an enforcer of those legal requirements, and that's usually bound to property. So in the classic Teutonic German tribes, or even into earlier than that Roman civil law, everything is related to property, and there's an understood element to ownership, and that if it's a body property, or it's a house, or it's tools, or it's a workshop, whatever the relationship is, that there's a known way, a method of dealing with disputes and ownership and particularly around arrears or debts or payments made to and why. So the legal structure is a very old, you could say, particularly the Germanic foundational from the thing 2,000 years ago, and it's intertwined, as I say, with an authority figure. So the king or jarl or chief will have a law or a legal system that is more or less a web that is entangled every single denizen that has to pay tribute to him. And this is how we get to where Hobbes starts us in his massive tome, the Leviathan, on all the interactions from disparate and diverse peoples who happen to reside and are citizens of a singular state. And this can seem like it's almost tautological, or there's an infinite regress or loop here where it's always authority, law, threat. But as Schmitt outlines, you do have this sovereign, you have a person, a head, making the decisions in the extreme state, in the exception. And this is where we define our authority, and from the authority we're then deigned to be given laws. The laws are reflections of the authority, and they're enforced by threat and, as I say, might or force. Now, these are compulsions, so you're made to do these things. You're not impelled, but you are compelled. And that a lot of the law is ordained, or it's you could almost say it's proclamated. Not that you have to be prescriptive to it, but you have to obey it in the regards to which it is intended to be used. Which is now where you get, obviously, judges and magistrates having their own perceptions and subjective understandings of law, because there is no very tight and perfect way of understanding words. Peirce knew this when he introduced semiotics and pragmatism, and then Wittgenstein wrote several thousand words on this in Tractatus and then Philosophical Investigations on how we are incapable of actually defining and meaning in a way that's completely lossless in terms of value. Any case, we do have these laws and legal systems that reflects the social fabric that we exist in, and then also the wills and wants of the authority, usually the sovereign. Schmitt here makes a point around Locke's inability to define who the authority is given, because Locke speaks a lot to authority but does not designate to whom it's given. And this is the important part of having a sovereign, is that they are the authority, they are the enforcer and designer and upholder of law. And that's how you get this facsimile of law to authority. It's that this is understood as that if you have a parental law in the house and you tell your kids and you command them, you have these commandments of living in the house, then you are de facto the sovereign, and then de jure the sovereign, and then you are also, in terms of having to back up the threat of the law, that if your child misbehaves in a way that they already know is a malfeasance, that there is a comeuppance, there is a, if they are transgressing, there is a punishment to that. So obviously, hopefully you don't have too many of these directives and precepts at home, but if you do, you will hopefully now get in the analogy what I mean by the sovereign of the state being the one who makes the terms, and particularly in the extreme and the exceptions. When there is a decision to be made, you have to be the one that decides, because if you're not, then you're not the sovereign. If you let the toddler tell you what to do, the toddler's the sovereign, and they've made the decision, they're now the authority. And that's how you get this relationship to the state, is you have the sovereign, and the hierarchical understanding of society obeys that, and the structure is just a reflection of that, and that's why it's this proxy for power. It bears out legitimacy, so the power is born out of this legitimacy of an authority, and it isn't this normative structure where we would say, yes, of course the president is always the sovereign, or yes, the king is always the sovereign, because if it was normative, there would never be transferal of power through other means. You would never have a coup, you would never have regicide, you would always have the same legal structure, and an inability to change that would then obviously have this normative version of a legal political system, which we do not have. And Schmitt goes on a lot about this in his book, The Theory of the Political, but also a lot of his other works and his essays, which you can also read. The point about exceptions is also interesting because Schmitt says they're not codified. So if they're not codified in the way that they're allowed to exist independently of human interactions and existence, then you have a gap, and there is this vacuum, you would say, of power that we assume is filled by the sovereign. And this assumption is what gives us this quasi-juridical part and portion of living, where you think you're abiding by rules that probably exist, and if you were to, say, veer off into the wrong direction, you might think and perceive yourself as being or performing illegal ventures, and thus you'd have the risk of punishment from that. And that's exactly how we can think of the relationship. This also speaks into why law is this counsel, and it's not this command. It's a way of thinking as laws related to the sovereign thinking of what he wants out of a social system. So they're not this infallible, prescriptive, as I said before, commandments or statutes, but it's much more around, we want you to behave and do things in a certain way, so this is the likely rule. And it's obviously the understanding that there are negative rules, so you only break them instead of actually living positively by them. They're to bound you from going outside of the limits, if that makes sense. So the legal system is structured in such a way that it's a complete ensconcing of your life and your ability to do things, because the sovereign has decided that your freedom basically ends where his wills and wants are clashed, or there is this if you think of a Venn diagram, that you can't have your wants and wills cross over with the king's or the sovereign's, because his take preeminence, and that's where you get these legal and structural delineations. And this is what a writ is, or having something be canon is about this fact that there is a non you can say it was undestructible, but there's a inviolable, it's immutable. There's nothing to do about this part until the sovereign says otherwise, or if he's introduced to a situation in which an extreme situation which he's no longer sovereign in, which, as I said before, usually is like a civil war or a coup. I think another quote here, which is quite a good reflection of how at least Hobbes understood this idea, you say that princes succeed one another, and one judge passeth, another cometh. Nay, heaven and earth shall pass, but not one tittle of the law of nature shall pass, for it is the eternal law of God. And this is where we see a transcendent factor to Hobbes that we won't see after what you might call the Enlightenment, but this 19th century atheism movement, where there was a less obedience and obsequiousness to the rules of God, and how the Pope had a stranglehold on a lot of these edicts around behavior and about transgressions, which we can then say is now under the purview of the sovereign. So we have basically taken and made redundant religious law and supplanted it with a completely civil, and if not, as I said, common, then a mandated constitutional law, which is what Schmitt understood as being inviolable, that if there is a constitution, then you have to obey the transference of power under that constitution, otherwise it loses its validity. And it is also one of those occasions where you will be a treasonous, perfidious wretch if you were to not obey the constitution that you had signed on to uphold, regardless of who was in power. The excerpt here maybe from Schmitt is a good way to start on how he understood the hierarchical order. And so he says, to the last, a basic norm. The hierarchical order that is legally valid in the state rests on the premise that authorizations and competences emanate from the uniform central point to the lowest point. The highest competence cannot be traceable to a person or to a socio-psychological power complex, but only to the sovereign order in the unity of the system of norms. And this is very typical of Schmitt in how his promulgation of exactly what the structure he understood required by a constitutional law, common law system reflected into a political system, because the two are naturally intertwined. And Hobbes also had a notion on this where he says the interpretation of the law of nature is the sentence of the judge constituted by the sovereign authority to hear and determine such controversies as depend thereon, and consisteth in the application of the law to the present case. For in the act of judicature the judge doth no more but consider whether the demand of the party be consonant to natural reason and equity, and the sentence he giveth is therefore the interpretation of the law of nature, which interpretation is authentic, not because it is his private sentence, but because he giveth it by authority of the sovereign, whereby it becomes the sovereign's sentence, which is law for that time to the parties pleading. And there's this continuation of and strain of thought around this law and juridical backing of an authority, both from a political and you could say theoretical standpoint here with what we're talking about philosophers, but in real life, in that when we consider the legal system and laws, we naturally think of, if we think about ourselves in interacting with those laws, that there is the police to uphold these, and that there is, in states of emergency, the army if there's martial law. So we can naturally understand that there are consequences for violating certain structures in the political juridical system. From this, I think it's fairly obvious that when power structures exist in ways that feel ephemeral but very real at the same time, they bring their own power. So the lesson here a little bit around knowing and understanding political legal structures is that if you are to abide by them, you need to know how to interact with them in a way that serves your purposes. And we talked a little bit on Machiavelli and how to get to that powerful position, but this is a much more structured understanding of what it means to live in a democracy and what the reflection of a liberal democracy is in the way that the legal structure and the requirements for you are as a citizen. Now, you can take power in a liberal democracy much easier and in a more simple way than you can in a monarchic or a feudal government, for instance, where there's a required power struggle because you have primogeniture and you have a birthright to the sovereign, such that if you wanted to be sovereign and you were a lowly knight or a merchant, it would require some forming of an army almost and battling against, and as Cromwell showed, you can supplant and supervene in this way yourself into being the sovereign. The last part here maybe that we can consider around is Schmitt's discussion on the political system, but to say no skill in manipulating the weapons of power will enable a political system to survive even a single generation. The idea is indispensable to the very essence of politics, because without authority, politics has no being, and without an ethical support for conviction, there is no authority. And this is, as I've reiterated several times in the video, a very necessary interaction with authority law, and how the existence of the law presupposes the might or the force of the authority in both enacting and then upholding a legal structure. And that you can be an enemy of the state as long as there is a state, whereas if you're persona non grata or you've been exiled, I mean, you're in your negative relationship to the state, you're still presupposing and confirming the existence of this state, and by having a state you have a sovereign, and a sovereign has their wants and wills, and they'll reflect this in the legal system. It's this very natural and you almost call it seamless process, and it's got such nice synergies that we can almost admire its beauty in the way that it's constructed from the Western perspective. Laws and legal systems have been vastly different across different cultures, but in Western Europe we have, and the derivatives of Western European law, either constitutional or civil or common, are fairly intricate and also established well in the realm of previously Roman law, and how it has been built through religious, Catholic, and then Christian law and religious laws into a purely civil and sovereign law. Lastly, I think it's worth maybe having just a commentary a little bit on the existential power of the sovereign, and that if you behead the snake, this is a very real consideration around the continuation of a legal system and its power, and how you think about power in a legal way determines a lot about how you interact in the power system itself. And so if you encounter a new legal system which reflects a different type of power, so say you go into a country with a much more democratic and republic version of legal structuring, and they have things like direct democracy instead of maybe you came from a dictatorship, then your interaction with the power structures will be vastly different, and what you fear and what you're able to accomplish will also be different. And this is how and why it's really important to understand, at least if not on a case-by-case level or a very diligent legal scholar, then at least on a very high almost philosophical level, the power systems.